Estate planning is vital to your legacy and family's well-being. Creating a will and any necessary trusts can reduce your tax burden while providing for your loved ones and ensuring that your wishes are carried out after your death. There are several essential legal documents that you should have in place no matter where you are in life. A will appoints fiduciaries and directs who should receive your assets upon your death. It also nominates a personal representative or executor to navigate the probate process. It also appoints guardians for your minor children and directs who should receive specific possessions, such as jewelry, pictures, family heirlooms, or your favorite pet, and what should happen to your electronic assets, such as social media accounts. A codicil is a written amendment to a will. If you die without a will in place, intestate, your property will pass via the predetermined intestate succession rules under state law. These rules are the state's attempt to distribute a deceased person's assets in a sensible way. However, this one-size-fits-all method does not allow you to choose what will work best for your unique needs. If you want to control the disposition of your own assets rather than the de facto plan, you will need to have at least a will in place. The will may also contain provisions providing that any minor children receive their inheritance in trust with a named trustee. This type of trust is called a testamentary trust, and it eliminates the need for a conservatorship to handle the assets you leave for minor children. For example, a parent of minor children may sign a will that provides that testamentary trusts will be established if the parent passes away prior to the children reaching age 25. Without such language, another court process is required to manage minor children's assets. A healthcare proxy appoints someone to represent you, advocate for your health, and make medical decisions on your behalf if you are incapacitated. Related documents include an advance directive, which allows you to describe how much end-of-life care you wish to receive, and a HIPAA authorization, which allows loved ones to access your medical records. A power of attorney gives an agent of your choosing the authority to manage your legal and financial matters, such as paying your bills and taxes. Springing powers of attorney are effective in estate planning as they come into effect after certain conditions are met, typically when the principal becomes disabled or mentally incompetent. There are many reasons why you may wish to include one or more trusts in your estate plan. While a will provides for a direct distribution of your assets, a trust is a way to hold property for the benefit of another person. The creator of the trust designates a person known as the trustee to manage and distribute the assets for a beneficiary. When a trust is created by a will, it is known as a testamentary trust. Your will can direct that some assets be distributed directly and others be put into trust. Trusts can also be created during your lifetime. A revocable living trust can hold your assets while allowing you to maintain control over them during your lifetime. Property held in trust avoids the probate process, so your heirs will avoid the delays and costs associated with probating an estate. A revocable trust also allows you to appoint a successor trustee to administer your assets if you are unable, and to administer assets for your beneficiaries after your death, ensuring that your heirs are provided for and receive their inheritance outright only when they are ready to handle the responsibility. You can also place major assets in such trust so that your trustee can distribute them according to your instructions directly from the trust after your death without the need to wait for the process of probating the will. They are flexible, and certain types of revocable living trusts can significantly reduce estate taxes. When a person dies with a will, the surrogate court must approve the will. This process is known as probate. The will is filed with the court by the proposed executor, and interested parties are given proper notice so that any challenges to the validity of the will may be heard. If the will is approved, the court will issue letters testamentary which permit the executor to take legal title of the deceased person's assets. The executor must pay any debts of the estate and can then begin distributing the assets according to the instructions in the will. The first step in the process of creating a will is to take a thorough inventory of your assets. You will need to know the fair market value of any real estate you own, and you should also consider how certain resources are titled. For instance, if you have an account with the designated beneficiary, those funds will pass directly to that individual outside of your estate. It is also prudent to think about potential people who could serve as executor, guardian, and agent. After discussion, strategy, preparation, and review of the estate planning documents, we will also meet with 2 witnesses and a notary for a formal signing in compliance with state-required formalities in order for the wills to be legally recognized in probate proceedings. You cannot predict the future, but you can be prepared for it.
Visit us at asyourcounsel.com for more information on our full range of concierge legal services.